if we look into our JJ Act, where children are involved in offences, there are provisions that juvenile to be released on probation under care of any parent, guardian or any fit person, or under care of any fit institution, and if both things fit, the child can be given under supervision of a probation officer under his jurisdiction. But sentencing of a young offender, there is a provision in section 6 where it is mandatory on the court to write or explain why the young offender below 21 years of age not granting probation, or why the court refusing probation to the convict. Under this, we may refer some cases where the court insisting to look into provision of section 6. In Ishar Das v. State of Punjab, court held that where the young offender was below 21 years of age, the trial court should look into why the benefit of probation not being granted. Similarly, in Srimati Moni v. State of Kerala, the court held that it is mandatory on the part of the court to extend the benefit of probation to the offenders if he is below 21 years of age. But in Sadek and another versus State of West Bengal, where at the trial stage no question of 21 years age was raised, the High Court in Calcutta not granted probation on the ground it was not raised in the trial stage. In Municipal Corporation of Delhi versus State of Delhi, the court, however, granted benefit of probation because of the age of the offender was below 21 years of age. But the more controversial section now in Probation of Offenders Act is section 12, disqualification attached to conviction. Section 12 says that where an offender released under section 4 of Probation of Offenders Act, any disqualification attached to the conviction would not affect the offender. If we look into some cases where Supreme Court in various cases varied its principles. In Shankar Das versus Union of India, the then Chief Justice Y.B. Chandrachud held that where a government employee being convicted for parking scooter in no parking zone, he should not be removed from service and is a fit case to extend benefit of probation, and if as he is given benefit of probation, he should not be dismissed under Article 311 of our Constitution. And our framers of the Constitution not thought that for parking in no parking area of a scooter, an employee should lost his job. But in Tikaram versus B.K. Seth, another, the court overruled the earlier Shankar Das versus Union of India, and dismissal of the service from the service by a government employee on conviction under their service rule been upheld, and that is followed in Horichand versus Director of School Education. But again in Ved Prakash versus Union of India, the Supreme Court held that benefit or disqualification attached to conviction includes that his service should not be affected for giving probation under section 4 of the Act. Similarly, Lalman Verma versus Punjab State Power Corporation Limited, again in 2012, the Supreme Court held upholding the Tikaram, returning to Tikaram principle, that conviction in any way the government has right to dismiss or remove him from service. In fact, if we look into the various decisions of the Supreme Court, there is a question of interpretation of section 12 of the PO Act. It is based on traditional attitude. Traditional attitude means that in our interpretation of penal statute, normally strict principle of interpretation being followed. But if it is against the legislature, in that case we have to think, because there is a principle, intention of legislature predominates. What is the intention of legislature in passing Probation of Offenders Act? If we go to the minutes of the dissent meaning, where it was raised on section 12, that section 12 is essential for rehabilitation. So it is a contrary interpretation from the intention of legislature for which the Probation of Offenders Act, particularly section 12, was inserted. And there is ambiguity, and whenever there is ambiguity, the penal statute principle says it should be resolved in favor of the convict. So it is against the principle of rule of interpretation which the Supreme Court in various cases decided. If we look into reformation of the offender and removing him and from the service, these are two conflicting principles. So this aspect requires and demanding review of the Supreme Court on its various judgments. As we have noted that probation also we have in plea bargaining. In the plea bargaining is a process whereby the accused and the prosecutor in criminal case work out a mutually satisfactory disposition, and in the process of disposition, if after accepted guilty or there is a conviction, the court can accept or grant probation as within the plea bargaining process. And in the plea bargaining process, public prosecutor, investigator, the accused and the victim, if all agreed, the probation can be granted under section 265(b) of the Criminal Procedure Code. But the soul of probation system is in our self-correction process. An empirical study in West Bengal reveals that majority of probationers are illiterate, unskilled workers, they are poor, agricultural laborers, and of rural background. Also, there is no intensive supervision of the probation work, as one probation officer is to work 3,253 square kilometer area, where no intensive supervision is possible. So where no intensive supervision, no rehabilitation process, and all are poor, in spite of that, study reveals 70% ex-probationers have been leading to a normal life without any rehabilitation programs of the probation department. In fact, it happened because probation system has an inherent efficiency of self-correction, whereby by getting that opportunity, the offender realized is wrong. He is giving the opportunity to think that yes, he has given an opportunity to correct himself, to return to normal life. And probation system working for last more than 150 years in not only Indian legal system, throughout the globe, because of its inherent efficiency. So probation as a system is a very effective system. The question is in efficiency. Efficiency level varied from place to place, but probation as a system having its efficiency, inherent self-correction process, this self-correction made the probation as part of criminal justice administration. So criminal justice administration, probation is very much essential in the sentencing disposition. Without correction, the object of punishment to help the offenders or the convicted person to return to normal life would have been impossible. At least part of the selective offenders need this probation, and that's why probation is in all the countries' legal system.